Lily is very different than me. Her story is different than me. Yet at the same time, I brought more of myself to this movie than I ever have before. And I think that more than any movie I've ever done, like, Lily is such a ball buster. I am rotten to the core when it comes to that. I am very, like, if I'm not busting your balls, then you should be worried. Then I'm mad at you. Then I don't love you. You know, and just the way that I sort of use humor and levity in moments of sadness or pain, because that's the prism through which I can cope and deflect, and I smile in sad moments because it's just how I process things.
Hi, besties. It's Katie from Without a Crystal Ball. Welcome back to my channel. It's another day. It's another Blake Lively PR stunt. Today, it is a amicus brief that was filed in court by 3 nonprofit organizations that helped to draft the law AB 933, which is the law that Blake Lively is trying to hide behind in order to say whatever she wants about Justin Baldoni outside of evidence, outside of facts, and outside of the fact that she's the one that caused harm in this case. Outside of the fact that her own company at one time was literally accused of SH, and she buried those claims. And outside of all of that, an amicus brief, which is generally not part of a motion to dismiss. Amicus briefs are generally filed in the Court of Appeals. And in this case, the brief is being used to try to influence the judge to dismiss a case and taking claims as fact that have not been determined as fact in the court. So today was one of those days. And there was also another one, a filing by Jen Abel against Stephanie Jones that will be overshadowed by this amicus brief that is all but a PR stunt, because this amicus brief is months late and irrelevant to the motion to dismiss. It's a group of lawmakers that helped make a law that want to tell a judge that if you rule wrong on this, you will hurt everyone. While they claim to support Lively, they fail to realize that Lively's claims cannot be trusted. And that's my opinion. But Jen Abel is fighting back against Stephanie Jones. Abel, whose phone was hacked and used as splicing and dicing to create the concept of a alleged smear campaign by Stephanie Jones, who then handed over the contents of that to Blake Lively through a sham subpoena and lawsuit in the state of New York. Ignore the fact that laws were violated by Lively. Ignore the fact that there's hacking allegations here. Ignore the fact that there's wiretapping charges in these lawsuits. Ignore the fact that there's extortion. We are supposed to also ignore all of the evidence, the long history of Blake Lively's lies and deception, and her husband's lies and deception, and their threats against people, and their intimidation and their bullying. Ignore all of that. We are supposed to just accept as fact that Blake Lively said it happened to her, even though there's no evidence. And because she doesn't have a single witness that can come forward on her behalf, because no one saw it and no one will corroborate it, and all of her evidence has literally been dismantled and shred apart through actual evidence, now she's relying on advocacy groups that help draft laws to tell a judge, you need to throw out this case that Justin has filed because we said so. Their level of using filings for PR knows no bound. But before we go into that, I want to just bring something up, because there are women that have been victimized in this case. There's one woman in particular. Her name's Jennifer Abel. She's a PR publicist that works in the state of California. I don't know if you're familiar with her. And there's another woman named Melissa Nathan. Both of these women have been maligned in the public and called aiders and abettors of sexual harassment that led smear campaigns, even though they had nothing to do with that, even though there was no smear campaign. There are actual victims here that are women, Jennifer Abel and Melissa Nathan, that are being harmed in this lawsuit via false allegations. And as you know, Jennifer Abel has some actions that she has brought against Stephanie Jones. And it is actually Stephanie Jones who started the whole smear campaign against Blake Lively. It was Stephanie Jones who did it all. And Stephanie Jones, her employee, former employee Jennifer Abel, is being sued by Blake Lively, even though the time period that Blake Lively is suing Jennifer Abel for, she was an employee of Stephanie Jones, working for Stephanie Jones, and being a public relations professional under Jones Works. For some reason, Blake Lively is not suing Jones Works, even though it was Jones Works and their employees that quote unquote smeared her. I want to just share with you their response to Stephanie's motion to dismiss because it's a thing of beauty. Do you remember when I stated that Stephanie was inserting screenshots and referencing complaints and answers that are outside of the complaint, the third party complaint, and outside of the complaint in general? And that Stephanie was adding irrelevant information as factual allegations that had nothing to do with the third party complaint? Well, they noticed that and they asked the court to disregard their improper factual allegations. They said, when deciding on a Rule 12b-6, courts may review only a narrow universe of materials, which includes facts stated on the face of the complaint, documents appended to the complaint or incorporated in the complaint by reference, matters of which judicial notice may be taken, as well as documents not expressly incorporated by reference in the complaint, nevertheless integral to the complaint. So stating you need to stay within inside of the complaint. Here's what they said Jones Works did. Jones Works improperly cites Lively's amended complaint to introduce alleged facts in support of the motion. However, when determining whether allegations in a third-party complaint can withstand a motion to dismiss, the defendant third-party plaintiff is not deemed to have admitted the allegations in the main actions complaint. To the contrary, the allegations of the initial underlying pleading are irrelevant. Nonetheless, the motion improperly cites her amended complaint 14 times. 14 times. None of them can be considered on this motion. Also argue that Jones Works routinely cites Abel's amended answer to Lively's amended complaint and to Abel's amended answer to Jones Works complaints. Even assuming the court takes judicial notice of Abel's other pleadings, the court should not consider the spliced and or cherry-picked communications that Jones Works attempts to spin into factual allegations. For instance, citing paragraph 76 through 86 of Abel's amended answer and pasting parts of what are alleged to be text message into the motion, Jones Works misrepresents to the court that Abel admits she actively worked to undermine Jones Works' reputation. A basic review of Abel's amended answer shows that in response, she either denied the allegations or admitted to sending the referenced communication and denied that Jones Works' pleading had accurately characterized the communication. As another example of her deceptive conduct, citing a paragraph 33 of her amended answer to Lively's amended complaint, Jones Works claims that Abel developed and executed a smear campaign to bury and destroy Lively. In truth, paragraph 33 admits that Abel sent a communication, specifically denies the communications and their context are characterized accurately in the complaint. The court should reject all of her effort to mischaracterize Abel's factual allegations. If you have to splice and dice your content and splice and dice your response and lie and try to mislead a court, a judge isn't stupid. The judge can read what you are saying and see that you're not representing this as fact. It's amazing how these PR people can spin these documents and they think they're working in PR and they forget that they're working in court. What really bothers me about the amount of power and influence that Blake Lively has is that she can get advocacy groups to take her at face value because of her name and because of her husband's name and because these large corporations make movies for them. And yet these people, these advocacy groups, these supporters of her, they all say that Blake represents all women. And I think, I don't know. I've made claims of SH and SA. I actually went to the police and wasn't believed. And you know what? When I was going through my process, not once did any advocacy group intervene in my case and say that if the police didn't charge this guy, then somehow it would be injustice to all victims. I truly hate when absolutes are made. When you say, if you do this, then everything else will be X. Like it puts into your mind doom or gloom. If you don't do this, it's catastrophe and the world will end. It's a fear tactic and it's veiled under this concept of advocacy. A single ruling in court on a flawed case, on a lying plaintiff making false allegations. And if a judge rules and does not grant the motion to dismiss, that doesn't mean it's a blatant disregard of other victims. It means that this victim isn't believed. And in this case with Jen Abel, her perpetrator is her former boss, Stephanie Jones. And you'll never make me think otherwise. Stephanie Jones is the one that went to the Daily Mail and started this whole press movement against Blake. But Stephanie was the one that said that went to the Daily Mail. Stephanie's the one that called it a nothing burger. Stephanie's the one that went out to defend Justin. When Justin and Jamie at Wayfarer said, do not talk to the press, we are not speaking to the press, no one was talking to the press. They cannot cite one time that Jen Abel is on record with anyone. They cannot cite a single person or a single story that Jen Abel put out into the public that was in retaliation to whatever claims that Blake Lively made. Blake Lively is using sexual harassment as a weapon, and she knows how to use loopholes and laws in her favor. And it sucks to be on the receiving end of this kind of litigation for Jen Abel, because how do you prove a negative? You can't. She has all kinds of evidence that's documented that shows what she did and did not do. She has provided most of this to the court, either through text messages with Justin, where Justin provides his side because she can't provide her side because Stephanie stole it from her, or Melissa Nathan shows her side and they can see the full context between Jen and Melissa. And all the while, Stephanie Jones was involved in all of that. And let's not be disillusioned here. Do you know who's actually being retaliated against? Jen Abel. Because in her lawsuit for the amended complaint, for the third-party complaints, she is being sued because of losses she incurred in the discharge of her duties of employment. That's retaliation. She's being sued because of things that happened when she left her job. Accusations were made against her by her former boss because her former boss is the one that did it and is framing Jen Abel. And it's her former boss that hacked into the phone and gave Blake whatever Blake wanted to prove her point. And the fact that in Blake's complaint, she can literally say that Jen Abel was working for Jones Works and was an employee of Jones Works and not include Jones Works in the lawsuit is insane. Because you know who else was involved in this? There were other people at Jones Works that were a part of Justin's file that were managing his PR. There was a guy that was also involved in this. Why isn't Blake suing the guy? He was as much of a part of it. He was the one talking to them. He was the one that was adding her to text threads, and they had meetings about everything and how they were going to coordinate the PR. Jen wasn't the only point person. She was like a team of people. Why isn't Blake suing the entire team? Why isn't Blake suing the whole tag team? Because it's not about suing anyone that's did anything wrong. It's about retaliation. Blake and Stephanie Jones are retaliating, and then they're claiming they're the ones being retaliated against. And something that's being I think lost on a lot of people is that Wayfarer discussed getting an attorney in August, early August, before this quote unquote smear campaign started. And Brian Friedman was called by Melissa Nathan on August 12th. August 12th. August 12th. Jed was hired, I think, on August 8th. The movie premiered on August 7th. So Blake is going to say a retaliation campaign happened in 4 days. 4 days. They were discussing hiring a lawyer all the way back in May. Do you really think this team was going to launch a retaliation campaign against a woman that had been threatening to sue them for months? And then do you really think that Brian Friedman would have come in and unethically aided and abetted a smear campaign against Blake Lively? And how does anything even compare to all of the stuff that Blake and Ryan put out about Justin Baldoni to the press, all of the articles to the Daily Mail and to Page Six about Justin, the unwanted kissing, the lingering kiss, the fat shaming that we've all seen didn't happen. Blake Lively's lies over lies over lies. And Jen Abel literally talking to Melissa Nathan about talking to Brian Friedman on August 12th. August 13th, more conversations about Brian Friedman. Brian Friedman came into this case in August. Wayfarer was planning a lawsuit against Blake because on August 12th, Blake said, if you don't put this out about me and apologize for this production, the gloves will come off. And when the gloves came off, they hired Brian Friedman. Why? What benefit does it have for Justin to smear his own movie and the leading actress in his movie? There's no benefit. It only hurts his movie. And who's the one that actually smeared who? Who's the one that was constantly running to the press? It was Stephanie. And who's the one that screwed up the PR strategy that they had developed of not responding to the press? Who was the one that went to the press? Stephanie Jones. And in their response to her motion to dismiss, they say, the third-party complaint also alleges that Lively's claims against Abel are grounded upon acts that Abel performed in furtherance of Jones Works' business, and that Abel was employed and directed by Jones Works and Stephanie Jones to do. Specifically, Abel's pleading alleges that the conduct alleged by Lively to have been committed by Abel and to have been caused harm to Lively consists of public relations activities on behalf of Wayfarer and Baldoni during the time period when they were clients of Jones Works. To the extent any of such conduct by Abel was undertaken as alleged, which Abel disputes, it was undertaken in obedience to Jones Works' directions. And indeed, the third-party complaint alleges that according to Lively's own pleadings, Abel's position as an employee of Jones Works directly gave rise to the so-called retaliatory campaign of public relations activities against Lively, which Abel disputes. The third-party complaint alleges that Lively's allegations against Abel, the veracity of which Abel disputes, are of conduct and communications directed at the press and the public to garner good publicity and to eliminate or minimize bad publicity for their clients, Wayfarer and Baldoni, activities which are the very essence of the public relations profession. Notably, not only does the third-party complaint allege that Stephanie Jones directed Abel to perform any purported public relations activities that are the subject of Lively's claims, but the third-party complaint also alleges that Jones Works owner Stephanie Jones participated in any such activities. Specifically, the third-party complaint alleges that Stephanie Jones' public relations blunders and incompetent handling of communications with the press only caused negative stories concerning Lively to circulate further and attract greater attention. Hence, the court should not give weight to Jones Works' improper factual allegations that Abel went rogue. The third-party complaint alleges that Abel was named as a defendant by Lively only because of and in direct consequence of Abel's discharge of her duties as a competent public relations professional employed by Jones Works, and that Abel acted within the scope of her authority, and that Jones Works profited and was enriched by the fees paid by Wayfarer and Baldoni for public relations services. That Jones Works directed Abel to carry out the alleged public relations activities that are the basis for Lively's claims, and that Abel was not at fault and bore no responsibility for Lively's claims. And then it goes on to say, to distract the court from Abel's well-pleaded allegations in the third-party complaint, they cite Abel's pleadings in the related case of Jones versus Abel, and then mischaracterize the nature of the allegations therein, citing to paragraphs 75 to 82 and of Abel's amended counterclaims in the Jones case. Jones Works incorrectly contends that Abel, coordinated an unsanctioned smear campaign for Wayfarer and Baldoni against Lively in purported defiance of Stephanie Jones's instructions. In truth, Abel alleges in the Jones case that Stephanie Jones participated in meetings, calls, and written correspondence related to public relations crisis involving Baldoni and Lively. Jones was copied on virtually all communications during this period and was privy to Wayfair's predicament and its chosen strategy of non-confrontation. Jones admitted that she was deeply involved in strategy, planning, and account management and high-level PR and media communication in August 2024. And Jones would have been contemporaneously aware of any smear campaign against Lively if it existed, and in contravention of Wayfair's instructions to not speak with the press about Lively, Jones spoke with the Daily Mail and sparked a chain of unfortunate developments from a public relations perspective and concerning Lively. Hence, the amended counterclaims in the Jones case allege that Jones sanctioned and participated in any public relations campaign at issue in Lively's pleadings and did not reject it, as Jones Works now contends. Jones Works' contention that the alleged public relations campaign at issue in Lively's claims represents a significant departure from Abel's normal duties and were beyond the scope of her employment is refuted by the third-party allegations, which the court must assume are true. As detailed above, the pleading alleges that Jones Works is a public relations firm. Wayfarer and Baldoni were their clients. Abel was employed by Jones Works to provide PR services. Any public relations services were provided by Abel to Wayfarer and Baldoni that are in the subject of Lively's claims were performed to garner good publicity and to eliminate or minimize bad publicity for their clients, activities which are the very essence of PR professionals. Jones Works and Jones directed the public relation activities at issue. Stated differently, the third-party complaint sufficiently alleges that the conduct in which Abel alleged engaged were her normal duties and within the scope of her employment. Basically, the nutshell is that they hired Melissa Nathan, and Nathan didn't need to do much. And all Abel did was her normal job. And as for Jones Works' contention that Abel cannot plead innocence or mistake, that is a red herring. Abel does not allege that she made an error or in judgment or mistake, but rather that she carried out her public relations duties as she was employed and directed to by Jones Works. Jen Abel has a right to defend herself against claims that are being made against her, as does Justin Baldoni. And under the Sixth Amendment in the United States, we all have a right to defend ourselves against claims, and we have a right to due process. And due process also isn't just about criminal court, it's about civil court. And a part of due process in the United States federal court is that someone gets to defend themselves against claims of sexual harassment or sexual assault or whatever the claim is. And another aspect of due process under the U.S. Constitution is that you are able to file counterclaims against the person that's bringing claims against you. It's a fundamental right for every United States citizen. It doesn't matter if you're a man or a woman. It's a right to all people. And what this California law is trying to state is that if you bring a claim of sexual harassment or sexual assault and you make it publicly known and you don't file something in court, that you can't be sued and that no one has a right to sue you. And that if they do, it's retaliation. And that's not what the Constitution says. What this law is doing is it's being the judge, the jury, and the executioner, and it's actually the opposite of due process, and it's the opposite that we are instructed as United States citizens that someone is innocent until proven guilty. And just because someone brings a claim doesn't mean they're guilty. And that in the state of New York, you can bring just about any claims and it's barred from defamation. And so, as Judge Lehman has stated, not all court filings in New York should be taken as fact and should be actually read with a grain of salt. So then to go to a court after which the statement was made, Blake Lively has brought in the big guns and brought in organizations who helped draft this law in the state of California, which I believe is unconstitutional. And I'm a victim of SA and SH. I hate that this is happening, but you have to respect the Constitution. You can't deny someone the right to defend themselves. And you can't allow someone carte blanche to just make up whatever they want, because there's always going to be bad actors. And there are up to 10% of claims of SA and SH that are false. So that means there are going to automatically be people that abuse the law and weaponize this law to say whatever they want about people. And so 3 separate companies, the ERA, the California Employment Lawyers Association, it's a organization of 1,300 California attorneys who primarily represent employees in a wide range of employment cases, and the California Women's Law Center are going to address the court about issues in the motion to dismiss. It's another way for Blake to get someone else to argue to the court that they need to throw out her case. And immediately after this was filed, the LA Times had a statement released by these organizations. So it's a press release. That's all this is. It says the proposed brief would help this court by explaining the purpose and legislation history of California Assembly Bill 933 at issue in the case. And they enacted not AB 933, now codified at California Civil Code 47.1 to combat the onslaught of retaliatory defamation suits filed against victims of sexual assault and harassment who speak out about their abuse, and specifically to shield them from a discovery process that has become one of the prime weapons in such suits. The irony here is that Blake already has her own discovery, and she's actually abusing Justin and wants information on the rights of the movie. But whatever, California people that want attention in the media. The proposed brief begins by situating AB 933 in a broader context. In recent years, retaliatory defamation suits have become a core part of abusers' playbook to deny abuse, attack victims' credibility, and cast themselves as the real victims, with devastating consequences for survivors and the public at large. Someone with the resources of Miss Lively is an aberration. Most survivors are low or middle income. Advocates, including Amici, have seen survivors buried under legal defense costs they cannot afford, while others struggle to obtain legal counsel. None of this has to do with Blake Lively. Next, the brief traces the specific legislative history of AB 933, highlighting its twin purpose to shield victims from discovery processes by allowing them to prevail at motion to dismiss stage in most circumstances, and to remedy the financial and physiological costs of retaliatory defamation litigation and deter abusers from pursuing such litigation in the first place. They're saying that this is to champion the rights of workers and victims of SH and SA, and to share a special interest in ensuring the courts apply the intended legal approach to this new statute to ensure that all Californians, particularly low and middle income individuals who cannot afford legal defense for speaking out about harassment and abuse, enjoy the full and robust protection that state lawmakers intended. You know, it's an odd choice for them to intervene, but they got a headline out of it, right? Victims advocates stand with Blake Lively. And in their brief, they tell the judge that, everything that Blake has said is true. And they accuse Justin Baldoni of using Darvo tactics. Who's the one that's constantly Darvoing her victims? Blake Lively. In the multiple amicus briefs, which I'm not going to read because the judge hasn't approved them, they try to blame Baldoni for ruining Blake and Taylor's relationship, even though it was Blake that brought Taylor into the situation. And Taylor doesn't support Blake. So how is it Baldoni's fault that Blake threatened Taylor Swift? It's not. So why are these out of place and irrelevant? Under the federal rules of procedure, in order for an amicus brief to be accepted into the court, it has to be filed 7 days after the initial brief was filed by the party that they're supporting. And they're supporting Blake's motion to dismiss. Okay. Blake filed her motion to dismiss on March 20th. If they were serious about this brief, it would have been filed on March 27th to support Blake Lively. Instead, they've waited 2 months. Blake's brief wasn't fully briefed until mid-April. The judge has the time from the motions fully briefed moment up to 6 months to rule. They are filing out of time, and it has nothing to do with this case. Because Blake is the first one to bring this into her court case doesn't mean Judge Lyman will rule on it. And it only has to do with defamation. Blake is being sued for much more than defamation here. There has been so many different people that have come out, and so many people that have that are opportunistic in this. And I'm not discounting the victims that this is claiming to support, but if you're a mother of a son, and I am, laws that chill the speech and the defense of a man against a woman is scary because there's plenty of Blake Lively's out there. There's lots of Amber Heards, and there's a lot of Robin Browns from Sister Wives. There's women that lie. There are women that fabricate stories of sexual harassment. There are women that weaponize whatever they need against them to get their way. There are women that commit crimes. There are women that murder, that commit fraud, that go to jail. Just being a woman doesn't mean that you're a good person. Just means you're a woman. And I do understand there is a culture of fear, and it is scary. And oftentimes, as victims, we are not believed. But designing laws that then take rights from other people doesn't help anyone. Laws need to be looking at the Constitution. And don't blame someone for fighting on if it's constitutionally valid. Blame the lawmakers for not foreseeing this problem ahead of time. There are other laws that have been struck down as unconstitutional that have been filed and put into law in California. They actually had a law that was overturned where California made it illegal, made it a requirement for every single company to have at least 3 women on the board of directors of any large of any publicly held company. So if you were a company in the state of California, you automatically had to have 3 women on the board, regardless of who was qualified or not. And the law was struck down because of the equal rights of all citizens to apply for a job. And if there's all equal candidates and they all have the same background, the companies are allowed to pick the right candidate regardless of gender. Being a woman is hard sometimes. I mean, we definitely get the raw end of the deal, but at the same time, we can't demand special treatment. Being equal doesn't mean we get something that's more than what someone else gets. Men aren't seeking and demanding the courts not allow victims to press charges against them. Imagine if that was a law. It's no different than a law that says you can't defend yourself. Imagine being accused of a crime you didn't commit, and then the judge says you don't get to defend yourself, you're going to jail. And it's just because someone said you did it. What kind of justice system is that? Blake is not the token victim of sexual harassment. And the amount of power she wields is evident by the fact that these large organizations are intervening into her case and trying to persuade a judge to dismiss her case and taking all of it as irrelevant, and that Justin has no grounds whatsoever for this. It's just a retaliation case. Well, that's weird. Justin was thinking of filing a lawsuit against her in August before she even filed against him. So how is it retaliation? She filed first ahead of him, and now it looks like he's retaliating against her. And that, my friends, is Darville. So what are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.